Beloved Creator, we give thanks for our family in every sense of the word. Gathering together has no comparison, for in one another's presence we share our auric fields, can embrace and vibe on many levels beyond the visible. We thank you for our intuitive nature, our ability to read what others are putting out just by tuning into their energy. For we recognize that we are energy beings. We generate and vibrate uniquely. Gathering together is food for the emotions. Our senses are more keen, more turned on, and alert when face to face. Being the social animals that we are, we thank you for bringing us together, often closer, deeper, wider than with our blood-related families. We're a marriage of sorts, for we are kindred spirits, one igniting the other and sharing ideas and the history and emotions behind them. The bond runs deep and feels old, even ancient at times. So in this moment, we can be silent in our gratitude, grateful for old friends, kindred souls who have found one another once again, picking up where we left off, as if there were no lifetimes we had to bridge to do so. Gratitude, Creator, for the love, the glue that binds us, and for the joy in it. And so it is. Well, this is the document. Here's a second. Yeah, everyone, we signed this Saturday when we met. So this is the 2-page document. This is the first page. And then this is the signed page. So we got quite a few signatures. And I won't read all of the standard parts. So this is a cease and desist order and a claim of cognizance by the Civilian Court of Record, docket number 10062023 OSJA. Notice, Oregon Health Authority, OHA, Department of Human Services, DHS, Children's Protective Services, CPS et alia, Oregon Supreme Court, including civil and municipal courts on Oregon, law enforcement officers on Oregon. Taking our children is no longer tolerated. Issuing them case numbers, phony court-issued warrants for arrest of parents, treating the people as chattel is criminal and will be prosecuted. The sovereign Oregonian men and women with their children on the land and soil of Oregon without ruler or subjects are sui juris, and thereby have the rightful jurisdiction of the causes which the persons in the de facto jurisdiction have commenced out of the sovereign Oregonians' de jure jurisdiction. A cognizance of exclusive jurisdiction, as that no other court shall hold pica and etc. hard. 509. This is a reference that is in the legal dictionary, and it's AB courts, comma, D. Our civilian court of record has been involved in numerous cases where entities in your jurisdiction have churlishly interfered in the lives of people. Policy does not trump people, yet regardless of any issue at hand, following orders and following policy by your actions takes precedent over the people with whom you are dealing. Your policies are not an acceptable one-size-fits-all action. Laissez-faire. We see the chattelization of us from the point of natus. We see the state of Oregon, aka the state of Oregon, all caps, claiming authority over us and our progeny, that, quote, our children, end quote, are not considered by the authority that should not be, to be ours, but whose responsibility is being superseded by that of the state. We see the creep of authority over us, our freedoms, our health and well-being, and that of our progeny. Attorneys, courts, law enforcement, and the untold minions of policy-mongers have no business with us, the people, yet you, they, make it a business. Your business making money on us through such as the corrupt money-making CRIS system, a RICO operation, child trafficking, satanic ritual abuse, SRA, organ harvesting, sex slaving, and the adrenochrome harvesting operations replete on our state, our nation, and worldwide. No more. Take heed. This is a matter of jurisdiction. Further, it is a matter of morality. Oregonian men and women with their progeny know better than any state with a capital S, or state, all caps, entity, what will serve babies, children, progeny, and their parents, grandparents, families. Custody issues must not be resolved by a parent who can afford an attorney to build a case against the other parent to buy custody of their child. We are in Article 3, Amendment 7, Civilian Court of Record, that along with Article 4, Section 4, knows that any federal court whose name begins with the United States is not a constitutional Article 3 court. No other courts can claim original jurisdiction. The Oregon Supreme Court has acquiesced to not being able to comply constitutionally due to an improper oath with the Constitution containing Article 7 amended and original. We will need to see any court's bona fides and those of the judges in that court, the feds at Portland DOJ, FBI, USMS, and the state of Oregon, aka all caps State of Oregon Attorney General and Secretary of State. 36 sheriffs and 38 prosecutors have also acquiesced to the Oregon Statewide General Assembly, that is, Article 1, Section 1 of Oregon's Constitution, and ex parte Milligan being implemented with Executive Order 100 Liber Code, martial law, FEMA, R is nullified. We have undeniable proof that all the other courts on Oregon are inferior to our people's civilian court of record, and all attorneys, judges, magistrates, justices, persons in black robes, and clerks are without a proper oath, status, standing, bond, and jurisdiction. From our de jure civilian court of record, in Article 3, 1 Supreme Court claiming original jurisdiction found in our Amendment 7 Common Law Court of Record, without appeal, in fact, Oregonian men and women are one of the people, not a person. Neither a U.S. nor United States nor all caps United States, quote, citizen, end quote, nor a citizen of any of its subdivisions. Should the court or judge or prosecutor or attorney or police without jurisdiction over the sovereign Oregonian people seek to contest this claim and demand, provide your written declaration to the name and address provided. Otherwise, they will have acquiesced to this document. You have 7 days, 14 days, and 21 days to rebut, or you acquiesce and default 3 times, thereby relinquishing all holds on all sovereign men, women with their progeny on Oregon. By order of our Superior Court, we are the provisional government on Oregon, the state among the several states of the United States of America's Constitution and Oregon's Constitution circa 1859. We are removing the de facto incorporated governance on Oregon and replacing it with our de jure government, and this is the manner we think proper. Any authority or so named health authority in its subdivisions over us is null and void and will not be complied with nor honored. And then it's our full faith with credit statement, and then the living testimony in the form of an affidavit of truth from Ron, and then the jurat, and we have 1, 2, 3, 4, 5, 6, 7 signatures plus Ron's clerk of court signature. So that'll be put in the mail tomorrow.
Perfect.
And
Thank you, Carly.
yeah.
Good
And
job,
I want
boss.
Wanted to
Beautiful.
mention-
hello, Major Carol. Thank you for taking my call. I expected I have only one shot at this, so I will get right to the point. We need a USMC major or better on Oregon to assess the situation for the Commandant of the Marines, General Eric M. Smith. We have lawfully determined this is a USMC responsibility. Notice to the agent is notice to the principal. Oregon has led the way and accomplished as much as we can without your assistance. All of us on Oregon implemented ex parte Milligan and nullified martial law with our civilian court of record. This in turn led us to our grand jury on Oregon as an Article 1, Section 1 social compact Oregon's provisional de jure government. We are a government with an Article 3, one Supreme Court claiming original jurisdiction found in Amendment 7, lawfully and legally, on Oregon in 2022. This was accomplished by the Oregon Statewide General Assembly, aka Article 1, Section 1. We have dozens of lawful documents, some of which are grand and petite jury trials, signed, sealed, stamped, and witnessed with proper proof of service and published on our website, www.orsja.org. These were acquiesced to by US DOJ, USMS, FBI, USMC, the state of Oregon, aka all caps State of Oregon's executive, legislative, judiciary, 36 sheriffs and 38 prosecutors, provost marshal, and JAG, defaulted to many times over. This same process, what we have done here on Oregon, is available to the other 32 states and commonwealths and the 17 territories. We need your help to reclaim our republic and to reestablish de jure as the law form as opposed to the de facto currently existing. We know our country is divided. The parties are divided within themselves. The people are in confusion and have been deceived to the point of not knowing the truth. Even the military is divided. We are de jure, people on the land and soil with the simplicity of common law, where only injury to another or to property is punishable, and where our courts have no judges but are provided to resolve issues among the people by the people. What we have instead, and have had since approximately 1861 and increasingly, are de facto courts, all corrupt RICO operations with their judges and attorneys benefiting from a monetized CRIS system, practicing authority over people with their incorporated, malevolent color of law governance, where the city of Portland is a subdivision of the county of Multnomah, is a subdivision of the state of Oregon, is a subdivision of the United States of Washington, District of Columbia, Inc., with forts, ports, armory, and needful buildings, operated by an industrial, military, executive, legislative, judicial, administrative, banker, FRN, BAR, Nazi, Jesuit, Khazarian, jihadist, communist, U.in. Big Pharma, medical, de facto, color of law, RICO society that should not be. So we took them out on Oregon, November 2022. What we need now from you is to take the work our Assembly and our Civilian Court of Record with its original jurisdiction has accomplished and force these de facto criminals, crooks, politicians, judges, attorneys, and DAs out of their positions of power based on our evidence of their corruption. They imposed what happened with the debacle that destroyed people's lives and businesses, their physical, mental, and emotional well-being, and continues to manifest serious problems in the culture. Our civilian marshal, Bobby Graves, Marine, and Deputy Marshal Jason McBride need support in enforcing the work we have done and are continuing to do to set things right for the people. We have taken to task all the agencies and associations and authorities on Oregon that interfere with our inherent God-given unalienable rights of peace, safety, and happiness. Now we need the clout only those of your agency can enforce. I made a statement. At what point did sensible enter into this? To walk away is sensible. To acquiesce, quisling. Inability to say truth to the de facto makes up 62.5% plus of the population. There is a large dispossessed population. A very small percentage will do Athens, Tennessee, 1946. I drew a line. Not one infringement on my unalienable rights granted by my God will go without challenge. It is codified on the land and soil of the United States of America's constitutional republican form of government circa 1859, original jurisdiction. The definition of sovereign are twofold here. A chief ruler with supreme power, one possessing sovereignty, Q.V. It is also applied to a king or other magistrate with limited powers. The second is, in the United States, the sovereignty resides in the body of the people. Vide Rutherford Institute 282, and that's a definition of sovereign from Bouvier, 1856. Sovereign are men and women with their progeny on the land and soil without ruler or subjects. The de jure jurisdiction of the United States of America's Constitution, circa 1859, original jurisdiction. The only codified government in history where, as in Article 1, Section 1 of Oregon's Constitution, circa 1859, quote, natural rights inherent in people, we declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. End quote. We returned to that on October and November 2022. Please accept this living testimony in the form of an affidavit of truth. This is from Ron Broman. I am known as one of the people, clerk of our civilian court of record, having implemented ex parte Milligan, nullifying Marshall Code, Lieber Code, FEMA, and Article 1, Section 1, aka Oregon Statewide General Assembly's Article 3.1 Supreme Court claiming original jurisdiction of Oregon, the state among the several states in the constitutionally de jure law form of the United States of America's Constitution and Oregon's Constitution, circa 1859, Ron Vroman, the common man, private. Ronald Charles Vroman in cursive on my birth certificate and as trustee of the Private Membership Association. Ronald Charles Vroman, the straw man in all caps, also known as Ronald Charles Vroman, Private Attorney General by the United States Congress, 42 U.S.C. 1988, and 18 U.S.C. 1510 and 18 U.S.C. 1512, and to be known as one of the people, also qualified criminal investigator and federal witness, and by living testimony without rebuttal. Status identified and without rebuttal in the city of Beaverton, public record, Beaverton Municipal Court, and the United States Federal District Court, Portland, Oregon. U.S. Navy veteran 5159365 discharged. The flesh, blood, and soul, body, mind, spirit, a man on Oregon, an Oregonian, a continuous traveler, a non-U.S. citizen, born August 14, 1938, Reno, Nevada, with two ancestors, a father and son direct bloodline that fought for New York in our revolution. My mother's father, born Stockwell Gonzalez in 1876, New Mexico. Mail, general delivery, Beaverton, Oregon, 97005, in brackets, 503-641-8375, Ron Vroman, 38 at gmail.com. With full faith and credit, governing laws established in this document at this time to be the following. Declaration of Independence, Articles of Confederation and Perpetual Union, Oregon's original constitutions, circa 1859, and the United States of America's Constitution, circa 1859, and ORCP 20A, Clearfield Doctrine, Accardi Doctrine, Ex parte Young, Ex parte Milligan, McCarran-Walters Act 1952, Judiciary Act 1789, Section 32, Judgment, nil deceit are all specifically called into this document. They are all governing law, which must be accepted. The current 13th and 14th Amendments are bogus and must be rejected. Take heed of the Blackstone commentaries. The DOJ is agent to the entity responsible for the enumerated requirements of Article 3, the one Supreme Court that must claim original jurisdiction to be a court. I would consider to have jurisdiction when found in conjunction with Amendment 7 court. The DOJ has failed miserably in their responsibility. We must do it ourselves. We define the words we use. We decide our methods of communication. This communique is not intended to mislead, defraud, deceive, or threaten in any way, and is submitted in good faith and with clean hands. I do lawful, not legal, and this is my best effort. I close with love, peace, harmony, and a prayer. A U.S. Marshal has determined my prayer is not a threat. He then reneged on his word, which is only good one time, praised the Lord, and passed the ammunition on Oregon without the state of Oregon, aka state of Oregon within the United States of America, the constitutional Republican form of government. Assistance request in lieu of a demand is what we think proper. Article 4, Section 4. Please send to us a major or better to examine our bona fides and report. Our Marshal Bobby Graves, USMC, wants a man that brings a battalion. I agree as an old sailor by sea up the Columbia. Bring your own brig. All the best of every good fortune for the good. The old white man talking head for the Oregon Statewide General Assembly, the Article 1, Section 1, Provisional Government on Oregon, 10/16/2023. Ron Broman. You'll find us at www.orsja.org. Thank you. Article 1, Section 1 of Oregon's Constitution, Natural Rights Inherent in People. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. Ex parte Milligan, 71 U.S. 4 Wall 2, 1866, was a landmark decision of the U.S. Supreme Court that ruled the application of military tribunals to citizens when civilian courts are still operating as unconstitutional. In this particular case, the court was unwilling to give President Abraham Lincoln's administration the power of military commission jurisdiction, part of the administration's controversial plan to deal with Union dissenters during the American Civil War. Justice David Davis, who delivered the majority opinion, stated that martial rule can never exist when the courts are open, and confined martial law to areas of military operations where war really prevails, and when it was a necessity to provide a substitute for a civil authority that had been overthrown. Chief Justice Salmon P. Chase and 3 associate justices filed a separate opinion concurring with the majority in the judgment,
but asserted that Congress had the power to authorize a military commission, although it had not done so in Milligan's case. The landmark case stemmed from a trial by a military commission of Lambton P. Milligan, for whom the case is named, Stephen Horsey, William A. Bowles, and Andrew Humphreys, that convened at Indianapolis on October 21, 1864. The charges against the men included, among others, conspiracy against the U.S. government, offering aid and comfort to the Confederates, and inciting rebellion. On December 10, 1864, Milligan, Bowles, and Horsey were found guilty on all charges and sentenced to hang. Humphreys was found guilty and sentenced to hard labor for the remainder of the war. The sentence for Humphreys was later modified, allowing his release. President Andrew Johnson commuted the sentences for Milligan, Bowles, and Horsey to life imprisonment. On May 10, 1865, Milligan's legal counsel filed a petition in the Circuit Court of the United States for the District of Indiana at Indianapolis for a writ of habeas corpus, which called for a justification of Milligan's arrest. A similar petition was filed on behalf of Bowles and Horsey. The two judges who reviewed Milligan's petition disagreed about the issue of whether the U.S. Constitution prohibited civilians from being tried by a military commission and passed the case to the U.S. Supreme Court. The case was argued before the court on March 5th and March 13th, 1866. Its decision was handed down on April 3rd, 1866. Prepared by Francis Lieber, promulgated as General Orders Number 100 by President Lincoln, 24th of April, 1863. Instructions for the Government of Armies of the United States in the Field, prepared by Francis Lieber, LLD, originally issued as General Orders Number 100, Adjutant General's Office, 1863, Washington, 1898, Government Printing Office. Article 1, Section 1 of Oregon's Constitution, Natural Rights Inherent in People. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. This is taken from oregonlaws.org.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying, and then he jumps out of the car, and he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.